Hi, so just in the interest of time, I'm going to start while we're still setting up. So I have the privilege of introducing you to the panel on environmental assessment. And as I'm sure everyone in this room knows, there have been some pretty major changes in terms of environmental assessment, especially at the federal level. And I'm also going to, just also in the interest of time, skip over bios. They're all in the program, so I encourage you to look at them right now. And I just want to introduce our first speaker. His name is Stephen Hazel. He's a prof here at University of Ottawa, as well as counsel at Ecovision Law, also in Ottawa. And he's going to be presenting on a presentation he's entitled Zombie Law.
Good afternoon. Searching for a theme for the Canadian Environmental Assessment Act 2012, I ran through a couple of ideas. One was Eliot's poem, The Hollow Men. Hollow men, stuffed men, leaning together with headpiece stuffed with straw. But no, sorry, that's Stephen Harper's Cabinet. No, so I thought that I guess we're trying to find my I thought that the concept of a zombie was quite appropriate. 1992, Parliament passed a law called the Canadian Environmental Assessment Act, which over the succeeding 20 years turned out to be a pretty effective law for reducing adverse environmental effects of projects and for promoting sustainability at the federal level. That law was repealed in July 2012, so it died, it was murdered, and they passed another law, SIA 2012, which in a way is like a reanimated corpse in its operation. So today I'm going to talk about this new creature that we have to deal with, this ghost, this shadow. So I'm just going to run through some of the key features of the Act, and then like some of my colleagues are going to take somewhat different tack. The first thing about this environmental assessment law is that it's not really a law, in that it is filled with discretion at almost every point. There is the only environmental assessments that are required are those that come from projects that are on a designated project list regulation. And even then, there is a screening process that says that the Environmental Assessment Agency can decide, even for those projects that are referred to it for environmental assessment, well, no, we don't really need to do an assessment on that. And the only exceptions really are for projects under the jurisdiction of the National Energy Board and the Canadian Nuclear Safety Commission. So there are a very small number of projects. I think only one so far has been referred under the new Act for which an environmental assessment is required. So, no legal requirements, almost. Second thing is, and this is one of the most important features of the Act, I think, is that there's been a reduction in the number of environmental assessments by basically 2 orders of magnitude. So in 2008, we had about 5,000 environmental assessments that were done every year, and that was way too many and way too much bureaucracy, and there was just lots of room for cutting back on that, no question. I mean, some people disagree with that comment, but I think we could have had a much tighter, more efficient process. David Estrin made the point yesterday, 99% of screenings under SIA, 99% of environmental assessments under SIA were screenings. That's true. Most of those probably didn't need to be done. Some of them, though, were actually quite important. Big projects that happened to be screened. Well, what do we got now? Since July, when the new legislation came into force, by my count, and I did the count last night, we had 14 standard EAs, which are comparable to comprehensive studies under the old Act. 14 have been initiated. No panels at all, although there are 10 that have been grandfathered from the previous law, and there are nine projects that are currently in the screening process. So that's a 7-month period, so we're on track for maybe having 30 to 40 a year compared to 5,000 4 or 5 years ago. So what are all these projects that are not going to be assessed? Justine's going to talk about the fact that the mining industry is perhaps as heavily impacted as it was before for environmental assessment. So where are all these projects that aren't being assessed? And like, it's staggering. It's truly staggering. In national parks, there is no requirement to do environmental assessments in national parks. Not anymore. Even though under the National Parks Act, ecological integrity is the key management priority under the Canada National Parks Act. No environmental assessments are required. Federally funded projects, no environmental assessments are required unless they happen to be designated on this regulation that I spoke of. So, other permit triggered projects, like projects that used to be triggered because they harmed fish habitat and needed an authorization. Those projects are by and large all gone. Same under the Navigable Waters Protection Act, where there's interference with navigation and a permit was required. Most of those projects are gone. So that's where all the reductions are coming from, or most of them anyway. So another feature of this act is that most of the environmental assessments that are done, and there's very few of them, they're only going to look at so-called federal effects. So federal effects include effects on fish, effects on migratory birds, effect on aquatic species at risk, and the possibility of adding other environmental effects under Schedule 2 to the Act, and I'm going to come back to that at the end. But just note for now that there's nothing on Schedule 2 of the Act right now. So, for most assessments, they're limited to assessment of these so-called federal effects. In addition, changes to the environment on federal lands in other provinces or outside Canada. And this one is really bizarre because what it basically says is that when you do an environmental assessment, the other provinces have actually, the environmental effects in other provinces are actually more important than the environmental effects in the province where the project is actually taking place. And America, if there's a project, say Sarnia, new tar sands refinery on the Canadian side of the river by Sarnia, which Shell was proposing at one point, the Americans would actually, for impacts in the United States, you would look at a complete suite of environmental effects, but on the Canadian side, in Ontario, you'd only look at federal effects, whatever they are. The Supreme Court in Old Man said that was kind of crazy. But anyway, we've come back to it. And then there are, with respect to Aboriginal peoples, the effects of any change on the environment on health and social conditions, etc., are also assessed. But I'll leave it at that. We could talk about that some more, but it's a complication I don't want to talk about right at the moment. If we're talking about the National Energy Board or the Canadian Nuclear Safety Commission, which have kind of a plenary authority to look at projects, like the NEB is looking at a major pipeline project, they can look at all sorts of effects that, whether they're notionally provincial or federal. So the Act does sort of recognize that the NEB and the CNSC can look at effects comprehensively. Well, that's sort of a good thing, I guess. One of the things that the Act does is that it limits public participation in panel reviews the way it used to be under the old Act, basically anybody could sign up and make a submission to a panel review that was looking, whether it was a pipeline project or oil and gas oil and gas pipeline, hydroelectric project, didn't matter. Anybody could show up and participate. Now you have to be an interested party. And they've got a definition of interested party. It's convoluted. It's defined twice in Section 2, which is, this Act is so full of, drafting errors. It's really pretty astonishing. But this is just one of the problems. So what's an interested party? It's a party directly affected by the carrying out of the project or someone having relevant information or expertise. Those determinations are going to be made on a panel-by-panel basis. So very likely you're going to have different panels making different determinations. I think there's considerable opportunity here for litigation in the future. Another feature of the new act is that they've centralized the administration. Under the old act, it had the principle of self-assessment, so-called. So that basically forced all of the departments, Fisheries and Oceans, Transport, Environment, Foreign Affairs, CETA, they all had to think about sustainability and when they were thinking about the projects that they wanted to do. They've decided to do away with that, and it's not necessarily a bad idea. On balance, it's probably a good idea. They've centralized it basically at the Environmental Assessment Agency and with the NEB and CNSC. So basically, the Environmental Assessment Agency is going to do virtually all of the assessments for the Government of Canada. Result, okay, much more streamlined process, but I think less motivation in other departments to actually think about sustainability. There are new legislated timeframes in the Act for screenings, for so-called standard environmental assessments, and for panels. Interestingly, if a review panel, I was involved in the Mackenzie Gas Project panel, that panel took 5 or 6 years. What the government can do under the new Act is basically pull the plug on that panel and say, sorry, you guys are taking too long. If they go over their time frame, we're taking it back. You guys are disbanded. So they would take the project back, and then the Environmental Assessment Agency would complete it. So that's a pretty significant hammer, and it may have a salutary effect on panels in terms of keeping them at their desk. One interesting time frame is the one for screenings. This 45-day timeline for the agency to decide whether or not a project should be assessed or whether or not it doesn't need assessment. So there's 45 days, they have to make a decision. I really wonder whether or not this is going to be a breach of the constitutionally entrenched Aboriginal right to consult. I don't know how you can expect a First Nation in some remote part of Canada to launch a lobby effort in Ottawa to convince the Environmental Assessment Agency that a particular mining project or whatever should be subject to assessment or not. I think it's likely that at the end of the day, the First Nation is going to say, listen, 45 days just isn't enough for us to figure out what we want, and if the agency has decided that no assessment is necessary, I see litigation there. Another feature in the Act is the so-called substitution by provincial processes. So this allows the government to basically turn over a federal EA to a provincial process, assuming that certain criteria have been met, and they're outlined there. They can go even further, and they can exempt, for substituted projects, they can exempt the whole assessment. And so the province gets to do, province does all the work, makes all the decision. But typically, there's a federal decision that's going to have to be made anyway, so if the federal government is cut off for the information, they're going to have to do some sort of assessment. So isn't that duplication? Was exactly what they're trying to avoid? Anyway, surprising. So, implication of all this, federal EA process is going to be heavily politicized. Lots of opportunities to lobby at the front end. If you're a tar sands company, well, you just get in there to Ottawa and make sure that your project doesn't get assessed, that it gets taken out of the process. The level of federal EA activity reduced by 2 orders of magnitude, and I think the substitution and exemption features are going to weaken and fragment environmental assessment across the country. One final coda. Could the zombie be made to march? And I think under certain circumstances it could, and that's because of the hyper broad discretion that's afforded to the federal government under the Act. What if we had a government that was actually interested in sustainability, and they were looking at this new Environmental Assessment Act and said, well, what could we do with this Act to, say, reduce greenhouse gas emissions across the country? What they could do is something like this. They could say, let's add projects that produce more than X tons of greenhouse gases to this so-called designated project list regulation. So we're capturing all of these projects, and they could be any type of project, that produce a certain amount of greenhouse gas emissions. Second, you could add greenhouse gas emissions to Schedule 2 of the Act, and you do that by order in council. You don't have to go to Parliament to do that. Just add greenhouse gas emissions to this schedule, and all of a sudden it becomes one of your federal components of the earth, so that under the law, under CA 3012, you're allowed to assess the environmental effects of the greenhouse gas emissions. So you do those things, you do those two things. Again, you can do it by regulation, don't need to consult Parliament, and then in a stroke, you could require environmental assessments of all high carbon projects across the country. And that would be, I mean, I can't imagine any government doing it, but that's theoretically possible. And that's what the two-edged sword of this particular law, because of the discretion. In the hands of a government like what we've got right now, they like it because they can expedite, you know, the various pipeline projects that they want to see approved. But in the hands of a different government, well, maybe we could do some different things. The zombie could be made to march. Thank you very much.
Is that close enough? Okay, I'll wiggle a lot, so because I want to point, but hopefully I won't forget to speak into the mic. Start off, since this is Saturday, my family day, I'm going to use it to put in a personal message, and that's please go read that book. It is about violence and the factors that, as a sort of on a global basis, can drive reductions in the level of violence, looking at all forms from domestic violence all the way to war. If you ask why is this relevant, war is, you know, what is it good for? Definitely not good for the environment. Several of the previous speakers referred to the Mercury Treaty that has just been negotiated. One of the things in looking at reducing mercury in products, up front, several countries insisted that military equipment be exempted from any consideration. That gives you an idea of how important war is in the issue of discussing environmental protection, but on its own it is very important. So there's my plug. It is a really good book. So disclaimers and cautions. Number one, I am not a lawyer, possibly the only one in this room who is not a lawyer. We don't have, contrary to sort of what you may have heard last year in the press, MAC, at least our mining industry, we did not have any privileged inside information. We were not consulted before the act was tabled, and we still don't have any privileged information, but we do ask questions. Another disclaimer or caution is that some parts of CA 2012 are not yet in place, so we're still at the stage where, you know, we're all speculating exactly how they're going to work. And finally, I'm talking about how our industry is affected by these acts and how we perceive them, and a lot of other sectors are affected very differently, so their perspective will be very different. As Stephen pointed out, we're kind of number one. A little bit of flowchart, and I do realize that different disciplines gather information differently. I use flowcharts a lot because I'm an engineer. Most of the members I deal with are engineers, scientists, and they understand flowcharts. They can't read text, lots and lots of text. It's also very helpful. I've found and I've been in this job for 21 years, dealt with a lot of legislation. I find it's a really, really helpful way to understand the flow between different parts of an act. I have encountered legislation that different pieces were drafted by different drafters, and they didn't cross-check, so you ended up with do loops, ended up with dead ends. It's a really good way to understand how it works. So this is a very simplified view of SIA, but it has all the major bits. So hopefully this will work. The front part is how you get into the act, and either through the designated project list, the formal name is Regulations Designating Physical Activities, or a ministerial order. If you go in through this route, there is a discretionary process, the screening, which can decide that no, you do not need an assessment, or yes, you do need an assessment. Most of our analysis and worries and advocacy have been focused on that front end. That's the part that is, so we haven't, so yes, some of the other issues that Stephen highlighted, the substitution and equivalency provision, those, panel versus standard, yes, those are for some people, and particularly from the non-proponent perspective, very important issues. But for our sector, we're still struggling with that front end as a worry. Some of the key features, it removes the federal decision trigger and replaces it with the projects list. It does have this flexibility to not assess projects on the list or to assess projects not on the list. Narrows it down to 2 types of assessment, standard and panel, 3 entities, agency, CNSC, and NEB, and I'll be talking exclusively to the agency. Our members have no projects that are subject to that end up in front of the NEB, so I know nothing about that process, and only uranium comes under the CNSC, so I generally leave that to the Canadian Nuclear Association. This substitution and equivalency, yes, they are available. There's none in practice, so we haven't seen what that elephant looks like. 2 features that in our worries about how to make it work we've kind of overlooked, but are potentially good things. It enables regional studies, and that's a tool, if used, could be extremely helpful, particularly in dealing with the issues of cumulative assessment, land use planning. It's something that all the stakeholders around the table have advocated on for many, many, many years, so it's nice to see it. Let's hope it gets used eventually. And the final decision is enforceable. That's a change from the previous act. Okay, now coming to us and SIA, and this table, I did not go into exactly how the registry allocates things to the various categories. But the basic thing that I take away from it is, we're number 1. Mining basically represents 65% right now of all the assessments being considered by the agency, and that could grow in the future. I don't want to make it sound like it's all complaints. There are some small process improvements introduced in SIA 2012. However, from the mining perspective, there is no reduction in federal oversight, and we didn't ask for it. There are very serious problems with the regulations designating physical activities. It was based on the old comprehensive studies list, so it was an obsolete list, and it wasn't developed for that purpose. So to use it as a trigger, it's causing all kinds of problems. We guessed that it would be a problem, but we underestimated how much of a problem it is, and the agency definitely underestimated how much of a problem it would create. And the final, well, I'll go into that in a little bit more detail, but one thing to note is the removal of this federal decision trigger removes the legal glue that kind of bound all the federal decisions with respect to a particular project together. Now we have to rely on policy to have those different pieces work together. Now coming back to that projects list, what we're seeing from our members, hearing from our members, is that for what we, under the old act and in sort of normal day-to-day, we think of as a project. Now, a little part of it, an activity, will be subject to SIA 2012, but another activity isn't, or the main part of the project isn't, and it does not appear to be related to whether it's of concern, whether it has risk of environmental impact. So it seems it's very puzzling. And that's partly why I hesitate about trying to read too much into these numbers, is I'm aware of a lot of projects out there that are kind of in limbo. The proponent and the front line of the agency is looking at it and saying, this doesn't make sense. This is not going to, you know, if we proceed through the process with the project as described, we're going to be laughed at. And so they're kind of still in the stage of saying, like, what do we do with this? How do we address it? So yeah, we are advocating, we are talking to the agency, we're talking to departments, and basically 3 messages that we're conveying. One is fix this regulations designating physical activities. That definitely, and we were promised that this would be done by the end of 2012. As you can tell from the calendar, it's a little bit past that, and we still don't even have Gazette 1. 2, manage the transition. And that transition is in SEA, but also in the Fisheries Act and Navigable Waters Prevention Act and Navigation Protection Act in the future. The big issue for us, if you think of from a proponent standpoint or even from the frontline agency, you start an assessment. The assessment is going to take, and the approvals process is going to take more than a year, more like 2 years from sort of first encounter to shovel in the ground, possibly longer. If in that time period the rules change as to what requires a permit or approval, what requires an assessment, the part that you were assessing becomes non-accessible and some other part becomes accessible, that's a nightmare. Combine that with somehow at the same time departments decided to have cutbacks and reorganizations, so the person that our members are talking to and asking for advice doesn't know how to interpret this and has just received a notice saying that their job may be terminated. They're not reacting in providing a service that is needed or the clarity. So this transition management is a really important issue. And finally, integration. This is really critical, and I'll go into that a little bit more. And yes, I'm going to run over time, but Rod said that was okay. And just to flag, the major improvement for our sector in federal environmental assessment was the 2010 amendment, which allowed the agency to initiate an assessment under SEA if there may be a trigger. They didn't have to wait for a federal department to say, yes, there will be a trigger. And that eliminated a huge amount of just spinning wheels, really speeded things up, allowed synchronization, and made things really work quite better. And a 2012 streamlining policy which promised integration of the Fisheries Act and navigable waters with respect to mining into the SEA assessment, which has to be now reviewed because of the changes in all those legislations. Whoops, wrong one, this one. Okay, flowchart. Flowchart number 1, and this is the simplified flowchart. It just shows you, this is something I use to communicate to our members. Most important one is to grasp that with the new system, their project may be subject to different types of requirements that are independent. So it may require a SEA assessment, it may also require a Fisheries Act authorization, it may require a Schedule II listing, it may require a proclamation under the Navigable Waters Protection Act, and it may be one of those, 2 of those, any, pick and choose, depending on the project. Whereas before it was a linear, if you required a decision, then you required an EA, and it was all integrated. It is confusing. It is also, the system isn't set up for that. So that is quite a big concern. The water questions, I won't but it's something you may want to look at afterwards. One water body, so it could be a pond, a creek, whatever, can be different things under different parts of federal legislation. And none of them are related really to one another, which complicates it and makes it quite challenging. This is what it will be like in the future. And one of the things, can I go backwards? No, okay. One of the things that that will be a question in 5-10 years, maybe when you're out there practicing. If you look at that slide and you say 65% of SEA assessments is the mining industry, The Section 36 and the Navigable Waters Protection Act, it looks like we're going to be 100% of those, mining industry, and we don't know about Section 35. You kind of ask the question of, are there no other activities that require that kind of federal oversight? Is this the best way to organize if that's the only sector you have the federal oversight of? I don't think anyone's going to ask that question today, but you know, after the transition period, that may be a question that arises. Okay. Future. Assuming that the agency proceeds very soon with fixing the regulations designating physical activities, I believe that they're still going to need that discretion, that there is no way to write down project descriptions that will work in a way that sensible people think it should work, that they're going to have to use the ministerial discretion to kind of add things and use the screening to take things out that don't make sense. And we've argued for using that ministerial discretion to overcome the shortcomings of that regulation. Value of substitution and equivalency, we're not sure how that's going to work out, because the only way it could be really useful is if that integration is maintained. So the Navigable Waters, Fisheries Act, and so on. If that's integrated in the EA, that's terrific. But if it isn't, then substitution equivalency would be a very bad thing. And just to kind of explain why it's so important is you design a mine, you design sort of here's the access road, here's where we put the mill, here's where we put the waste rock, here's how we're going to mine, and that decision has to take input from the Aboriginal communities. You know, take into consideration environmental protection, human protection, human interests, all those things factored in. You can't, you have to do that in an EA. You have to have a robust process. You have to have meaningful consultation. You can't then take that and say, okay, now I'm looking at federal jurisdiction, now I'm looking at water frequented by fish, and now I'm going to redesign the whole thing and consult all over again for some other purpose. That doesn't work. You need to have a robust, integrated process. Sorry, I get a little bit passionate about these things. The Fisheries Act, at this point, I would not bet on how exactly that's going to work out. A lot depends on that definition, on how is that commercial, recreational, and Aboriginal fishery defined, and I include some of the, whoops, wrong one, this one. Nah, go away. Uh-oh. Okay, final request, one little request, and as students that you may not be guilty, but your older colleagues in legal firms have been, over the last year, I have seen umpteen legal firm newsletters definitively stating exactly how the changes to the acts are going to affect the mining industry. And it was really obvious that someone read the government press release and that was all they read. They may have, if they claimed to know something about the mining industry, it meant that they watched Avatar. Please don't do that. It was really, really frustrating for me to have to issue, you know, notes to my members saying, please disregard everything you've read in the press, all the legal newsletters, you know, the federal government is not withdrawing from, you know, for mining from oversight. It is damaging to law firm reputation if you issue things definitively and it turns out to be wrong. That is not good for you. And even as an activist, be cautious. Please use words like most of the time or in most cases rather than in all cases, because people may believe you and then you may drive a reality that you wish to avoid. Thank you.
So thank you, Justina. That was Justina Laureline. She's from the Mining Association of Canada. And I neglected to mention in my introduction, my brief introduction, that all our speakers today on this panel have many years of experience working with SIA and now with SIA 2012. So next up we have Rod Northey. Sure. Just pull it up. There we go.
Well, you're almost at lunch and probably fed up with a bunch of lawyers, but hopefully I'm going to move this upbeat a little bit. SEIA, according to Stephen, has just disappeared from view and is a zombie walking around, and I'm here to encourage you to take a look at it as Justina just did, because there are some angles in there that I don't think the government quite anticipated, and I think they're ripe for future litigation. So I'm going to focus a little bit on that. And what I mean by litigation, I'm going to give you a context first. Why do we care if you're a public interest advocate, as you've heard before? I'm at a private firm now, and I have been all my career, 23 years, and I've done 20 to 30 bits of public interest litigation all along, 7 cases under SEIA, and I have a perfect record in the public interest. I lost all of them. So now I'm going to just talk, though, about why do we care about federal environmental assessment and SEIA? Why has it triggered so much litigation? 2 answers. One is because provincial environmental laws do not do all that they need to protect the environment, so people look elsewhere. The second answer is because there is no federal administrative tribunal that is charged with dealing with environmental effects of projects. Panel reviews are not decision makers, they're recommendation bodies only. There is a clear lack of any real oversight in a legal nature in the federal level, apart from the NEB dealing with energy and the CNSC dealing with nuclear. So what happens is, if you are in a dispute and you think about an Ontario equivalent to the Ontario Environmental Assessment Board or Review Tribunal, there is no federal equivalent. And that applies across the country. So what we have is the unfortunate situation of, if you want to get something done or have federal law enforced, you have to go to the courts. And in particular, the federal court, because of the way federal decision-making is exclusively limited to the federal court. So the starting point then for SEIA 2012 is it doesn't fix either of these systemic issues, but contains a number of novel features compared to earlier federal EA regimes, which is what I'm going to focus on. And it's relevant not merely to those of you that want to do public interest litigation, but as Justina just said, to those of you that want to act for mining companies or proponents. I don't think you'll see any of the stuff I'm about to talk to in any newsletter so far. And I didn't do a newsletter to get us here. So, this is pretty simple, but I think, speaking to a law school audience instead of a bunch of federal court judges, I will start with some more basic propositions than I might otherwise. Core principle for judicial review. So if you're a law student, young lawyer, senior lawyer, trying to figure out whether your client should go to court, there are a few things that are very simple to figure out. Go look at a legal instrument and find those provisions that confer duties or discretion. Those are where you start. Secondly, you go and look at statutory definitions. And thirdly, you look at purposes. Those 3 things inform a great deal of how you should think about the new SEIA. And lastly, even though we have the Baker case of administrative law that says it's okay and you can go off to court and even win challenging discretion, that has got to be regarded as the slimmest read of judicial review I can imagine. Every case in my 0 to 7 record involved duties. I could not even get the court to enforce duties. So be careful about proceeding about the exercise of discretion. I'm going to zip through this. You can look at the presentation. It will be available. These are the terms that are key. Designated projects is an artful term. I'm not going to spend time on this because I'm going to try in the limited time to get to the top 5 list of things that are going to cause some fun in SEIA. But do note then, just from this quick overview, that we have 2 different definitions of project in the same act. Here is the environment. This is important, not because of what it contains, which is obvious, but what it doesn't contain, which is it does not contain the human world except perhaps our roles as biological species. All the things we do to the economy, culture, society are not in this definition in any clear way. That is unlike other statutory regimes, like, for example, the Ontario Environmental Assessment Act, where everything that humans do is in play. So we need then to turn to the crazy thing called environmental effects. The print is small. That should not tell you it's because it's so inclusive. It's because it's so obscure and they need to define it in very precise ways to keep it obscure. So what we have is, the most important part of this takeaway is environmental effect, parentheses, mine, narrow. As Stephen said very well, look at the things that are normally the vast majority of things to worry about. We have fish and their habitat, aquatic species under the Species at Risk Act, migratory birds. You may have thought the environment was a little bigger than that. That's not how SIA thinks of it. For the vast majority of things we're talking about, that's what we're dealing with. Now, there is very special regard to Aboriginal peoples because of the constitutional obligations, I think, and I'm not going to say much about that other than I agree with Stephen that I think there are some serious problems with how the Act works, and I'm not going to speak to those today because my top 5 list, so to speak, is going to be directed at those which all Canadians can deal with and not just First Nations. But there are some serious issues, even with this kind of approach specified out, how the whole Act works there. Now, here's the second definition. Environmental effect, most important words not in the statute, my words, supplementary. This looks a little more interesting, but the important point to note is this only applies to the NEB and the CNSC. So, this is a very important term, federal lands, as we will see. And it's important because there is no federal environmental assessment regime on federal lands, but there is the peculiar requirement that any project that is to take place on federal lands can't cause significant effects. Now that's really got to be the simplest version of environmental assessment I've heard. You are prohibited from doing something significant. They don't tell you how you assess it. They don't prescribe any process, but you have a prohibition in play. That, of course, makes it on one of my top 5 lists of potential litigation. Statutory purposes, there are many, but the ones that are highlighted are the ones that I think are very germane to litigation because, of course, when you're interpreting legislation, one of the things you need to do is show your interpretation is consistent with purposes, and I think a number of public interest litigants are going to find the purposes highlighted here very important to what they may want to do. And by contrast, those who are trying to stay out of federal litigation in public interest domains need to start paying attention to how to do assessments that comply with these objectives. So the most important one is A. Purpose of the Act are to protect the components of the environment within the legislative authority of Parliament, who knows what that means exactly, but authority of Parliament from significant adverse environmental effects. I could give you a lecture on what word significant means, but all I'll say is nobody defines that, but that makes it very interesting for the court to figure out what it means. And then you have things B, C, and E. I've got very little time, so I'm going to move through my overview here. This is a very important provision, a duty under the term mandate in the statute. Everybody's supposed to apply their duties in the government in a way that protects the environment, human health, and applies the precautionary principle. That is an unbelievably important baseline indicator of what should happen, and I would say keep that in mind for anybody that's looking for what to do in the courts. All right, I keep talking about this stuff, so let's get to them. Here's the list. They're provisions novel to the new SIA. They're provisions that involve duties, not discretion, and they're set out in reverse order of potential exposure. Apologies to Letterman and those top 10 lists. So, target number 5. Very complicated in one respect, but it was highlighted by both Justine and Stephen. Substitution decisions of the minister. Now this looks like a nefarious exercise to hand things off to the province, and perhaps many people think it is. But it has another nefarious aspect to it. Column 1 looks good. Everything's a handoff. If the province asks for you to give them their EA mandate, you have to give it to them. But column 2 is interesting because what it says is that the minister can only approve that handoff if the minister is satisfied that the process to be substitute will include a consideration of the factors set out in subsection 19.1. Now, I'm not going to get into minutiae, but I've reproduced for you 19.1. And some of the things that most provincial EA regimes don't pay any attention to include effects of malfunctions and accidents, cumulative effects, significance of effects, alternative means of carrying out projects, and any change to a project that may be caused by the environment. So how are you going to do a substitution? And if a minister does do a substitution and the provincial regime doesn't deal with these effects, hello, federal court. Number 4, federal decisions on projects on federal lands, as I alluded to. Project carried out in federal lands. An authority must not carry out a project on federal lands or exercise any power or perform any duty or function conferred on it, blah, 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 unless the authority determines that carrying out of the project is not likely to cause significant adverse environmental effects. Or it determines it could do that, but the government and council, the cabinet decide they're justified. Well, this is all fascinating because there's absolutely no requirement to say what you're supposed to do to determine that. There's no process requirement. This is a special section in the Act. The rest of the Act does not apply to it. I will dare say right now there will be a very great number of authorities that don't follow that duty. There will be a great number of projects, therefore, that are illegal. Hello, federal court. Number 3, and this is where probably the most interesting thing starts, Target 3 agency decisions on screenings. As Stephen said very well, screenings are now a new game. It's a term that's been around since the 70s, but what it means now is something entirely different. It's not an EA, as it has been for the past 3-4 decades. It's something else. It's a precursor to an EA. And these are the things you're supposed to look at. Importantly, you're supposed to look at whether it may cause adverse environmental effects. You're not supposed to require an assessment of significance. You have regulations over on the right I've identified. The interesting piece, as Stephen alluded to, it's got to be done very quickly. Aboriginal people may be prejudiced. I dare say that federal officials trying to figure out what to do without assessing significance of effects are going to be in all kinds of problems, and that's going to be great ground for litigation. Number 2, now we get to the 2 most interesting things about SIA that are unprecedented. They are that SIA applies directly to proponents of projects. All previous regimes since the 70s all applied to the federal decision makers trying to carry out an EA of a project. Now we've got the proponents directly in play. So target number 2 is the proponent's duty to submit information to the agency. There are 2 regulations affecting what that means. The most important is the second down on the right side here, prescribed information for the description of a designated project. But you have a proponent now with a direct obligation to comply with the Act. They've never had that before. And who is to tell the proponent that they're subject to the Act? Well, if you're a member of the Mining Association, you are very lucky. You have Justina to tell you that the Act applies to you. If you're not a member of the Mining Association and you're relying on your illustrious Bay Street law firms, they have yet to tell you that the Act applies to you because the federal news releases don't explain that part. Now, dealing with this, there's an issue of incomplete information, but I will say it's 8.1 that's the mess. Are those proponents going to submit the proper information to the agency in the required time frame? I say they won't. And the most important thing I forgot to mention here is this applies to the proponents, not to agencies. You are not restricted, in my view, to going to federal court to challenge this. You can go anywhere to challenge this. It's a law of general application, not restricted by the prohibition in the Federal Court Act. All right, that looks pretty good if you're a public interest litigant thinking about what's happening. But here's the best one. Prohibition against the proponent carrying out its project prior to SIA compliance. Proponent of a designated project must not do any act or thing in connection with carrying out of the project, in whole or in part, if that act or thing may cause an environmental effect, unless the agency's made a decision, the proponent's complied with conditions of approval. So again, let's speak to the point. If you're in MAC and you're a member and you're told by Justina you better get that information in, you've escaped this mess. If you are not so well informed and you're a public interest body looking at this and wondering, or having clients and residents groups directly affected, and you're trying to decide between target 2 and target 1. So the good news in target 2 is they haven't submitted a project description, and you may say, whoa, that's pretty good. Maybe we should go off to court right now and say, submit it. Or do you just wait till they're really in the fire and then go to court on Section 6 and say, it's very interesting here. I'm glad to see they think they can carry out the project, but they don't have any federal approval. They never submitted the information. I see a court finding this very easy to implement and apply. And as I say, it's not the federal court that's limited. Why not? Because the Federal Courts Act is expressly about federal agencies and decision makers. This has nothing to do with them. Oops. Oh, now I'm back in that quagmire. How did you get out of this?
You have to click on the next, on the top one.
God.
Or just click something and then
Click something. Ah, great.
the center button.
Oh. Oh, great.
No, not help.
Well, help was illuminating, but it didn't get me anywhere. Oh, there we go.
Okay.
Thank you. Final slide. Okay. I think I saw the warning. Where am I? At 0? Okay. Many lawyers, and myself included, regard environmental assessment as the most important tool of environmental law. Why? Because it protects the environment before bad things happen. It's not after the fact. It's not reacting after the horses have left the barn. And we have a great example of that here. And Mr. Hazel, I'm going to point this out. He won't do it. But back in the mid-1980s, Stephen Hazel was a young, creative lawyer like you, maybe a bit more experienced than you. And he saw a law on federal environmental assessment where the federal government only saw guidelines. And that was something called the Environmental Assessment and Review Process Guidelines Order, ERPGO. Based on later success in the courts, a number of people with Stephen's impetus and others went off to federal court and they won, and that made ERPGO law as enforced by the Supreme Court of Canada in the Old Man decision in '92. All of that started in somebody's room, in somebody's head, in fact, about this law, this guidelines is legally enforceable, and we can do something about this in the courts, and there was success. The new SIA 2012 provides a new legal era for environmental assessment. Based on experience, it seems safe to say it is going to make law in places and ways that many yet do not see. Thanks very much.
Great, thank you so much. So we have time now for a few questions, if anyone has any.
Got a question, if you guys could discuss the constitutional authorities behind SIA and how they're impacted by the recent changes. And, no? And the idea of using or any increase in the use of riparian rights given the changes to navigable waters and SIA.
In 2 minutes? Steve, you want to try?
On the first part, I mean, I think there are serious constitutional issues relating to this, relating to SIA. In the case of, we'll talk about the mining industry, there are mine projects that are being put forward for environmental assessment, submitting their project descriptions. There may not even be a federal decision being made. If there's no federal decision being made, is it really constitutional for the federal government to require environmental assessments to be done? I think an argument may be constructed that there might be, but it's a whole new area. I mean, if you're talking about justification under peace, order, and good government, I mean, I don't think criminal law is going to work here, criminal law power. So, I mean, I think there are big issues.
Yes, I totally agree. If you go read the Old Man decision, you'll see how difficult the court found the then environmental assessment regime and how it tried to draw lines around that. This is a very different beast. I would say, to paraphrase something that was quoted in Old Man about federal EA being a Trojan horse, well, the horse is not only inside the gates, it's open and the soldiers are streaming out onto the streets. The government really does not know, in my view, how constitutional this works for the very reason Stephen said. And then the second constituency is the charter side and Aboriginal peoples. I again say I don't think the government appreciates how this regime is going to deal with those constitutional issues.
I guess I wanted to just add to and contribute to the conversation. The Mikisew Cree First Nation, they've launched a constitutional challenge to some of the omnibus legislation, and I think just to be reminded that these omnibus pieces of legislation did not include Indigenous peoples from the get-go, and just to keep that in mind, that there's, the constitutional treaty rights, the treaty themselves, and also the UN Declaration on the Rights of Indigenous Peoples. This is international human rights laws and protections, and this process to bring in and revise the legislation did not honor the international human rights laws as well as the treaty and Section 35.
I mean, yeah, I think it's. I mean, there is this question of whether or not the federal government or the provincial governments have a duty under the Constitution to consult First Nations before bringing forward legislative initiatives. I think that issue is out there.
Hi, is that on? Ramsey Hart with the Mining Watch Canada. One quick comment and a question. The comment, I guess, is following up on the concerns around process. Many of our concerns, and as members of the Canadian Environment Network, as Stephen was actively involved, a lot of our concerns around SIA 2012 were the process and how rushed it was. And our understanding, perhaps it's not accurate, but our understanding of the rush to get that legislation out was from pressure from industry, including the Mining Association of Canada and its members. And you could say that the Mining Association of Canada didn't have any inside information, but looking at the lobby registry and reports from the lobby registry, we know full well that some of the most active lobbyists on the Hill are associated with the mining industry. So I found, just in your comments about, oh, we didn't know anything ahead of time, we didn't have any insider information, a little bit misdirecting in terms of the influence that the mining industry has on federal legislation. And I think the fact that you have been told that there will be amendments to the designated project list is an indication of that, because I don't know if that's been made public. It hasn't been gotten, as far as I know, widely circulated. My question is, as Mining Watch was with our partners in Eco-Justice involved in the Red Chris case and the decisions around scoping and when is a project and when is a project not a project, I was talking about somebody at a break about where we landed with that with SIA 2012. So any clarification on that would be appreciated.
Okay, I'll answer it. Yeah, we do add quite a lot of advocacy, but this wasn't what we asked for. We're actually, you can check through the record, some of our materials on, in public. On the Fisheries Act, we explicitly asked the government not to amend it. On SIA, we also, well, you could see our presentation to the House of Commons. So it's
the government after it released SIA 2012.
Yeah, we actually did. We did say that no, this was before. Remember, SIA review was just before SIA 2012. The omnibus bills came out. So yeah, so these are not. I mean, and if you look at it and consider that the oversight of the federal government on our sector is not reduced, it would be strange if we had advocated for that. So we had not asked for those legislative changes. We do advocacy, and our advocacy was on this issue of integration, timeliness, providing clarity on when Section 35 and 36 of the Fisheries Act applied. So that has been our advocacy. We are regulated and subject to government laws, so we do not sort of speculate on things like should it have been an omnibus bill or not an omnibus bill, and we try to frankly avoid criticizing the government. We emphasize what are the problems and what solutions we need. So no, this whatever effort, whatever drove the government in this direction, it wasn't our lobby. In terms of the issue and the Red Chris decision, it's just very different right now, and that's something that is really problematic, and what's causing concern about the designated projects list is that it doesn't make a lot of sense, because it's no longer a project, it's now an activity. The consultation on amending the designated projects list, or the regulations designating physical activities, was last summer. As soon as they put it in law, they issued a request for comments. It was very rushed. I think the deadline was August 17th or something like that. Yeah, we provided very, so, and at that time, they said they would amend it by the end of
That's right.
December. And we periodically phone them up and say, you know, is the check in the mail? And they say not yet, so that's.
Well, I think the Red Chris decision is basically out the window. With how the Act has been revised, I don't think the project scope provisions that were in the former Act really are applicable at all to the current Act. So it's just in a sense where it's a whole new ballgame.
Okay, I'll chime in with a third opinion. I think the Red Chris decision, which legally was significant for a very brief moment in time until the government changed the then Act to eliminate its effect, we now have exactly what I think the end goals we're looking for, which is a project list, and you got to do an EA, and all the shenanigans about what triggers an EA have disappeared, because in the old days, which we haven't talked about, DFO could stymie a request to trigger a federal assessment for years. It proudly said to one legislative committee on my watch, 10 years they were proud they had not managed to trigger an EA despite all kinds of consultation on a project. So in my view, the project list has moved past all that obfuscation. I think it does probably have more, if I were to tip the balance towards the mining and the end goals, I would say the public is rewarded with the way the present list works, because it's now definitive what projects are in. You have this agency discretion, but it's certainly not the old days of DFO stymieing things. So how long that lasts with the current list, that is certainly a good guess, but I think it simplifies some things dramatically and improves what Canadians can get out of it. Thanks.
Hi, I'm actually a vegetation scientist, and one of my side projects is remediation and revegetation of mining piles. And I work particularly in the subarctic, so I have a question sort of akin to that. What you guys listed as your definition of environmental effects is a little bit vague and quite short, and I was hoping if you could expand on what the definition actually is, and then also comment on whether it takes into account how long the landscape takes to actually respond and to reclaim to its original state. So as such, like in the Arctic, the fact that you could have maybe the same biodiversity as in a lowland area, but it takes much longer for that landscape to return to what it used to be after, let's say, something like mining.
Okay. You want to take track of that?
I think from a legal perspective, that's an excellent question. That's one of the challenges that in defining permanent. I mean, from a substantive perspective, in a proper project design, reclamation has to, sorry. That one doesn't work? Okay. From a practical perspective, obviously, you know, the mine design will look at reclamation and so on. But in this legal construct, it's an open question what permanent alteration or destruction means when you have something that you will be reclaiming in the future, and whether that is taken at all into account in an EA. And we could go into how exactly the agency explained that environmental effects thing, and it had to do with birds and bees, literally. So bees, okay, how'd it go? If you're building a mine, you look at, you know, the aquatic species and so on. If you have no federal decision. If you have a federal decision, for example, you want to build an explosives plant that you need for blasting, then for the explosives plant, you look not just at the fish and the birds, but you also have to look at bees and any other part of the environment, but only for the explosives plant. The rest of the mine, you only look at the federal jurisdiction. I didn't laugh.
one thing I would say that north of 60, like in the 3 territories, and in other places as well, there's separate environmental assessment regimes that I think are way better than SIA 2012. So if you're talking about, say, in the Northwest Territories, taiga landscapes in the Northwest Territories, that the environmental assessment regime that would apply to that would be the Mackenzie Valley Resource Management Act and the environmental assessment regime under the MVRMA and not SIA 2012. So north of 60, it's a different sort of, it's a whole different scheme because of Aboriginal land claims that have basically the First Nations people and the Inuit basically drove better processes, in my view, in the north. Some may differ on that. Anybody else?
All right, so that ends the environmental assessment panel. Thank you to all our speakers. Yeah.